Good morning, everyone. Thank you for joining our Consumer Law CLE. My name is Kristen Salas. I am one of the mentor attorneys at the Dallas Volunteer Attorney Program. For those of you that are not familiar with DVAP, as we affectionately call ourselves, we are a joint project with Legal Aid of Northwest Texas and the Dallas Bar Association. And our primary mission is to match low-income Dallas residents with private attorneys that will work their case pro bono from start to finish. We take a wide variety of cases from family law to estate planning. And one of the big cases that we see a lot of is consumer law issues. And we get a wide variety of consumer law cases from faulty car repairs, faulty home repairs, all sorts of things. And we are in desperate need of attorneys that will take consumer cases, because right now we have more consumer cases than we have attorneys. So please reach out to us if you are willing to take a consumer case. And today, to teach us all about what we need to do on our consumer cases, our speaker is Kendall Hayden. Kendall is a member at Cozen O'Connor Law Firm. She focuses on commercial litigation and handles a wide variety of topics ranging from transportation to hospitality to environmental to employment and medical malpractice defense. She got her bachelor's at Texas A&M and her JD from SMU. She regularly helps mentor our DVAP volunteers on their consumer cases and has been a great asset. She is a former Pro Bono Coordinator of the Year award from DVAP and is a great resource. If you have questions during the presentation, please put them in the Q&A at the bottom. And if we have time at the end, Kendall will get to those. But without further ado, I will turn it over to Kendall.
Well, good morning, everyone. I am going to be looking down at my phone because I do not like to go over. I want to respect your time. So if you see me doing that, it's because I'm looking at my stopwatch. I'm really thankful to be asked to do this. I've done it several years in a row. And one of the reasons that I focus on consumer law, to be totally frank with you, is because when I started doing pro bono work, I did a lot of divorces and family law matters, and I wanted to get more civil experience that I thought might actually help me in my practice. And by the way, consumer law cases are really fun. So some of the things that I'm going to share with you today are actual real world consumer law cases that I've handled for DVAP, and they are actual results that I have obtained. And I'm going to share with you in case you want to do what I did and try out a consumer law case. That nobody gets left behind, that I did not know what swiping right or left meant. My esteemed colleague, Tyler Frankel, who works with me, is the one that came up with our theme for today. So I had to Google what swiping left and right means. So if you don't know what it means and you're like me and you were born in the 70s, swiping right on a dating app means that you like somebody. Swiping left means that you do not think that you are a match. So why do you want to hear what I have to say about consumer law? I will tell you that my first entree to consumer law was actually when I was in college, and I was working at Vincent and Elkins as a junior paralegal. And one of the partners sent an email around and said, does anybody here speak Spanish? And I, of course, being unafraid, I piped up and said, well, I speak Spanish, and I do speak fluent Spanish. And he asked me to come down to his office, and he said, I need to translate this manual from English into Spanish. It's a Bono clients in Houston, Texas, can understand what consumer law is all about. So that partner who asked me to come into his office, his name was Gib Walton. Gib Walton was the president of the Houston Bar Association. And I got to work alongside him, and I translated this book. This is an actual copy that you're looking at of the manual that I translated. This was probably in 1997. So I translated that into Spanish, and then later Gib got elected to be the president of the State Bar of Texas. And I served under him in a leadership capacity as a member of the Leadership State Bar of Texas, which those of you who are familiar with, Leadership Dallas, it was kind of like that, but for lawyers across Texas. And unfortunately, Gib passed away. But he was a longtime mentor to me, and I credit him with actually introducing me to consumer law before I ever went to law school. So in my actual practice, I've handled consumer class action claims. I frequently get DTPA allegations against some of my clients. I used to be an insurance coverage lawyer before I became a commercial litigator. So I handled a lot of DTPA violations under the insurance code. Because of the experience that I have had using my commercial practice in a consumer law setting for DVAP, DVAP actually asked me several years ago, would I be a DVAP mentoring attorney for them? And if you know, if you take on a case for DVAP, they have different types of lawyers that can mentor you through the process. So let's say you take on a criminal matter or a case that has a criminal aspect to it, which I've done before. There is a criminal DVAP mentoring attorney. There is a family law DVAP mentoring attorney. I am a consumer law DVAP mentoring attorney. So if you do not have any questions of me today, but you think of some questions as you hopefully take on your first case, please call me. I have people call me all the time when they're consumer, and I can walk you through some of the things that you may not know to do, or just some of the nuances about various consumer law things. The other thing that I have a little bit of experience with, or my firm does, is that we have a state attorney's general practice, which means that if you are a business and you are providing things to consumers, you could be audited or investigated by the Attorney General for the state of Texas, or in whichever state you operate in. And my law firm will come in and assist the business while it is being investigated by the Attorney General for that state. And the reason we can do that is because we have a relationship with all the attorneys general across the United States. So I also have some experience in how that looks. So what is something that you want to do to be a good match with a consumer law case? Well, first of all, you want to educate yourself. And that's why you're at the CLE, by the way, is what are some of the various causes of action you can bring? What are some of the things that are not going to allow you to? So about some of the overviews of consumer law in Texas. First of all, in order to bring, I'm getting a notification my internet connection is unstable. Hope that doesn't mean anything. A consumer is a specific definition under the Deceptive Trade Practices Act in Texas. And so generally speaking, I'm really going to be focused on the DTPA, or the Deceptive Trade Practices Act, during my presentation. And so in order to bring a cause of action under the DTPA in Texas, you have to first qualify as a consumer. So what is a consumer, and why do we have consumer law? So consumer law is really designed to protect the consumer. And so in our situation, it is typically going to be the person that you're representing as a pro bono lawyer. So my clients through DVAP are people who have purchased goods or services for personal use. And so that consumer law is designed to protect those consumers, our pro bono clients, from false advertising, sneaky sellers, seller, or telling you that, something's wrong with your car when it's not. These are all types of things that consumer law is designed to protect and to regulate. So those of you who may remember the DTPA laundry list, from maybe the bar exam, God help us, there's a lot of things on the laundry list that the DTPA is. These are some of the sort of popular laundry list items. The DTPA has a long list of things that are violations of the DTPA. And so these are just examples that I've shown you here, because these are the ones that are sort of the most popular, at least in the pro bono cases that I've handled that from a consumer law standpoint. And so again, remember, before any of these can apply to your client, the client first has to be a consumer. And so as I will show you in some of my examples, sometimes you can allege a DTPA violation if you don't have a consumer. Now, what I will also tell you is that sometimes in a pro bono setting, you're going after, as a consumer lawyer, somebody who maybe doesn't have any assets, somebody who's a little bit of a deadbeat, not always, and I'll show you some examples of when that isn't the case. But sometimes, even though my client may not qualify as a consumer, I allege the DTPA anyway, and I let the others raise that issue. So it's a kind of a fine line. You obviously don't want to be bringing frivolous claims, but be, concentrating on what a consumer is when you are thinking about what types of causes of action you want to bring. So the DTPA laundry list generally requires, by just a broad scope, to, as a consumer, seek or acquire goods or services. So remember that, seek or acquire goods or services. So if you just lost something, or you have a loss, but you didn't actually go seek to acquire goods or services, then you're probably not going to be qualified as a consumer. And I'll give you an example of one of my current pro bono clients who does not really qualify as a consumer because she loaned money to her boyfriend and he didn't pay her back. And so now she is out a significant amount of cash. But unfortunately, that does not qualify her as a consumer under the DTPA because she didn't seek or acquire goods or services. So keep that in mind. The other thing, obviously, you always want to keep in mind are the the DTPA is 2 years. Fraud in Texas actually can be extended in certain situations. It's not always. Breach of contract is 4 years. Tort and trespass and products liability are 2 years. Why am I sharing these particular causes of action with you? Because in my practice as a consumer pro bono lawyer, those are the ones that I generally am alleging. Okay, trespass, products liability, tort. That these are not at all exhaustive, but usually in the consumer law cases that I'm in, these are the causes of action that I care about. So generally speaking, a DTPA lawsuit has to be filed within 2 years after the date that the misleading or false act or deceptive occurred. Practice took, place over a period of years. To be safe, you need to start by calculating the statute of limitation from the act first. Of my pro bono client who loaned her boyfriend money, the date that you start calculating that statute is the date that he first didn't pay her back, or the date that the first note was due that he didn't pay. So what is a statute of limitation versus a statute of repose? If any of you do construction defect matters, which I handle, you know that than a statute of limitation. And so basically a statute of repose is the cutoff date, whereas a statute of limitation is a trigger date. So in a construction setting, and I have some construction defect matters where I was a consumer law pro bono lawyer against a construction company, which I will share that example with you. You cannot file a lawsuit against that construction company or the subcontractor more than 10 years after the date that the project was substantially completed. And as you might imagine, there's a whole host of law about what substantial completion means. So remember that some construction defects are not immediately discoverable. So the reason that you might have an opportunity to bring a lawsuit, more than 2 years after the house was built or whatever the situation is because sometimes those defects aren't actually manifesting until later, until after the 2-year typical tort time period would run for a statute of limitation. Same thing with product liability. There's also a statute of repose because may have been manufactured in the year 2023. It doesn't start showing problems until 2027, perhaps because it hasn't been distributed yet, or perhaps because it's been used to the public. So One of the things you can do to swipe right and to be a good match for a consumer law pro bono case is to educate your client. What is one of the first things you should do when you get the file? This is a hint. Of course, after you run the conflict and you've accepted the case, you should have, pardon me, an initial face-to-face meeting. I know people don't do that much anymore. In a world of Zoom and our pandemic, we've done everything so much online like we're doing right now. But I cannot tell you how few times, if any, I don't think I've ever had a pro bono consumer law case where I haven't met my client in person. They always are willing to come to your office. I work downtown. So, obviously getting them to the office sometimes is a little harder. I've gone to pro bono clients' homes before. I would, educate yourself and be careful about where you're going, because sometimes the neighborhoods aren't the best. But I've been to many, many pro bono clients' homes. Usually more than willing to come to you. One of the things that I had a great experience with, because I speak Spanish, I went to a pro bono client's house and helped them translate the will into Spanish so they could understand what it said. And when I left, I got this beautiful flower arrangement, and it was not actually flowers. What it was is the pro bono client had cut off the bottom of a 2-liter Coke bottle. And I don't know if you can imagine what that looks like, but it looks kind of like a little bowl. And she had flipped it over and painted it and made it look like flowers. And she did that in 4 or 5 different colors. And then underneath it attached green plastic straws. So she gave me this, what looked like a bouquet of flowers, which I still have to this day in my office. So that is a benefit in going to people's homes. I've also gotten a lot of really nice cards like greeting cards sent to me saying thank you. And so the clients that you will represent really do appreciate what you're doing. They usually are not sophisticated business people, so they don't always understand some of the things that they've done to swipe left, which I will share with you, that sometimes puts them in a predicament. So it's really some of the most rewarding work I've done in my legal career. The other thing you should do is you should educate don't hide the ball. I always the first thing I tell my opponent is, guess what? This is a pro bono case. Guess what? I have all the time in the world. So this is not a issue where I'm on a budget. I don't actually resolve. I'm here to represent my client. And a lot of times that is a little bit of a game changer. I had a car dealership that I sued, which I will share with you that story. And when I told them that I was representing the client pro bono and that I didn't care how many billable hours it took because I wasn't billing my time, we ended up getting a favorable settlement. So I would always encourage you to talk with the client. I would make sure that they understand that you're seeking damages. Make sure they understand that you intend to tender to their insurance carrier. So what I mean by that is most defendants that are businesses, and that's who you're usually going to be suing in a consumer law case, are going to have general liability insurance. And you always want to make sure that you are telling the defendant that you're going to seek to put their insurance carrier on the hook. I can show you how to do that as a former insurance coverage lawyer. I know how to work with insurance companies. It is also very important. Another swipe right tip, way out of insurance coverage. Some people who don't practice commercial or civil law don't understand how to write a lawsuit or a complaint or a petition that doesn't argue your client out of insurance coverage. And so a good example of that would be if you're suing car dealership, for example, you do not want to allege an intentional act, which can be difficult to do if you're suing under the DTPA, because oftentimes intentional acts are not going to be covered by a general liability policy. So if you are finding yourself in a situation where you want to represent a pro bono client in a consumer law case and you need to draft a petition, please feel free to call me and I can help you write it so that there is available insurance coverage if there is insurance that is protecting the company. The other thing that you're probably going to find yourself doing is making a deal. There are sometimes consumer law cases where the defendant doesn't have a lot. You're suing. or if you're suing a contractor who's gone out of business because he didn't do very good work. So a lot of times I find myself in a situation where I'm handling a pro bono case in a consumer law situation where we have a payment plan where the defendant pays back my client over a certain amount of time. And then on the flip side of that, I have handled a case on behalf of a defendant for DVAP where he's the one that sent me the card in the mail, where he was upside down on some sort of credit issue. And so there was a collections agency going after him, and I negotiated a payment plan for him to pay back the collections agency a certain amount of money per month over a 2-year time frame, which was a good result for him because that's all he could pay. So another thing that you might find yourself being ability to try a case, because these consumer law cases are not big cases. There's nothing preventing you from going to trial. If you are a young lawyer and want trial experience, this is a great way to get trial experience. Most judges in Dallas are very sympathetic to new lawyers that have never tried a case before. So this is a way that you can get trial experience. So what are some of the problems that I see? This is not a good match case. Well, a lot of consumers that are just don't have the paperwork when they signed the contract. And I'm not making these things up. They literally don't have the contract that they signed for their vehicle. The other thing that is sometimes a problem is when a family member gets involved, because sometimes the consumer law pro bono client either doesn't speak English, so their son comes along as a mobility issue, so the son comes along to help the client get to point A or point B. What you have to be careful about is the family member sometimes wants to control the case. And number one, that creates a privilege issue because you're not representing the family member. But number two, it could potentially be a conflict of interest if the son or the other family member, I keep using the word son because I've had a son in my office with my client that I'm remembering. It could create a situation if the son wants something different than what the parent wants. So just keep that in mind. And it could be a sister or anything like that. The other thing I've had happen is where the client calls me and her friend is the one that co-signed for her loan at the car dealership. That's an issue because you're not representing the friend, but the friend may be adversely affected if you decide to sue the car dealership, which I have done, because the friend is the one that's co-signed for the loan of the car. Also, don't forget that a lot of the defendants that we sue, at least in the pro bono cases I've had, about 50% to 60% of them do not have assets. So they're either a company that's gone defunct or a contractor that's no longer in business. They are somebody with terrible credit and a bad criminal history. So always manage the expectation up front with your client, because the pro bono client, usually, obviously, they're coming to us because they don't have the type of money that a lot of us have. $3,000 to them is a lot of money. And so my example of my transmission case cost $3,000 to fix. That defendant that failed to do the transmission repair correct in the first place probably doesn't have $3,000. So that is something that you should look at up front so that your client understands that while you may get a judgment against the consumer law defendant, you may never actually recover on the judgment. The other thing that you should know can be not necessarily a negative, but can be something that is unexpected, is that once you have one consumer law client who you're representing pro bono, they think that you can represent them in lots of other different cases. And so the way that you respond to that is, of course, you go to DVAP. And if you want to represent them, you have to go through the DVAP process if they're going to be a qualified DVAP client. But understand that there is a process by which each case should be vetted. And sometimes somebody who's a pro bono qualified client in 2023 may not be a pro bono qualified client in 2025. So just because somebody has an opportunity to work with you one time, I guarantee you they will call you again, but you need to make sure you go back to DVAP and make sure that that person still qualifies as a pro bono client, that you want to take on the case, that there's no conflict in you taking on the case, and all the other things that go on with taking any client in a new representation. So these are some of the resources that I have used when I have represented some law. Basically, social media is part of our presentation theme, so that's always something that is helpful. Actual media can also be helpful. And what I mean by that is sometimes you can use the media to your advantage. You have to make sure that you're not creating an ethical situation. But in my social media case that I'm going to share with you, where my client's been taken advantage of by somebody she met on a dating app, I'm thinking about using the actual media to leverage a settlement. And I have to make sure that that's okay. And before I do that, I'm going to speak with my chief marketing officer at my firm, because I can tell you in my commercial law practice that I have a situation where the media is not my friend. And so it's not always your friend, but sometimes, especially when you're representing the claimant, the media can be your friend. Sometimes when you are looking at resources like these, they cost money. For example, we have a service at our firm where something called background check light, but it costs, a little bit of money, like $20 or something to run. And so normally our firm will eat those costs. We don't solo practitioner, and maybe that's a different situation. Again, helping your client understand that some of these things cost money. Sometimes what I've realized when I have a resource that I need and I may not have the funds to pay for it because my client is pro bono, I've gotten some of my go-to experts, like my private investigators. I had an arborist one time, which is a tree expert, by the way. They did that for me for free. So a lot of times when people know that you're representing someone pro bono, and you're trying to help the claimant and the consumer, and they don't have the money, they will do you a favor, especially if you give them a lot of repeat business that you typically pay for. Some of the pitfalls. Again, I'm not making these things up. These are all things that my pro bono clients have done. They fail to put something in writing. They blank check. They sign contracts without reading them. And so, one of the things that you want to ask immediately up front is you want to ask for any and all paperwork associated with the transaction. A lot of times there is none. You want to make sure that you read the contracts that they have, because I guarantee you they probably didn't read them. The other things, are that there's sometimes documents out there that the client may not know to get. For example, they may not know to go get a report. A pro bono client who did know to go do that. So now let's talk about the fun stuff. And these are stories I cannot make up. These are actual cases or have handled. So I don't know if any of you have heard about the Tinder swindler, but this is a real story. This is a documentary, a British documentary on true crime about, this is actually him, by the way, the guy that you're looking at. This is the Tinder swindler. And basically what he did is he would manipulate women into giving him money and then not show up for dates with them and say, I can't make it, my enemies are after me. And he would basically come up with this weird shenanigan where he did it to like 15 different women, where people would give him money, and then he would use that money almost like a Ponzi scheme to acquire more money and manipulate more people. And so this is an actual true story. Well, I actually have a similar situation with my pro bono client. And let me say this to you also. Sometimes your clients pro bono were not always a pro bono qualified client. So the client that I am representing right now in a Tinder swindler situation was actually a safety specialist at a steel mill that I represent, and she no longer has a job. She has a daughter. She's a single mom. She is on government assistance, and she called and said, I don't have the money to hire a lawyer. Can you help me? And so I'm helping her, and she does qualify. DVAP qualified her within the appropriate poverty level. So essentially, it's kind of funny that we're looking at this guy on a boat, because she loaned money to her boyfriend. If any of you are listening, please don't ever do this. Lent money to her boyfriend to the tune of $30,000 and didn't get paid back. So we are now bringing a lawsuit against him for him to repay the debt that he owes her. This is the example I was talking about earlier, where she does not qualify as a consumer because she hasn't sought or acquired goods or services. She's loaned somebody money. So unfortunately, while I wish I could represent that she qualifies under the DTPA, she does not. And this is a situation where I think it's too big of a leap to argue that she's a consumer. But that's an example of a consumer law pro bono case where I'm trying to get her loan repaid back for her. And by the way, the guy that's done this to her has done it to other women on the internet. Interestingly, my client was contacted by who was also manipulated by the defendant. And he also took money from her. And so we are interviewing her right now to get her statement, and we will be using that in our lawsuit. This is maybe the case that I rewarding in all of my career. And this is my old nail salon. This is at Preston and Forest, for those of you who know Dallas. I used to go to this nail salon every 2 weeks. I now go to a different nail salon also every 2 weeks, but it's the same family. And I went to get my, bi-weekly mani-pedi, and my manicurist, my technician, said, doesn't speak very good English. She speaks mostly Vietnamese. And she showed me this paperwork in family court for an upcoming hearing date. And I looked at it and I realized that it was a child support hearing, and that she was trying to challenge the fact that the 3 children and so Claire, I've never set foot in a family courtroom. I do not do family law, but I at least knew enough to know that she would do better with a lawyer than without one. So for all of those that you do family law, God bless you, because it is a worse looking place than the criminal courthouse. There are so many young children there with their mothers just lining up for child support that it was really, and I have a 7-year-old, so it was difficult to watch. But I walked into the courtroom and I said, who in this courtroom looks like they know what they're doing? And I sat next to a guy with gray hair in the jury box, and while we were waiting, and I said, I need you to tell me how to go get child support for this woman. I have no idea how to do it. And so he taught me everything I needed to know about going in front of the assistant attorney general, who is the one that is there advocating for the child support for the parent who's in need. And basically, because I had gone to this nail salon for so long, I knew the owner, and the owner was the father of the 3 children, who was trying to act like he only made $10,000 a year, which if you can see my fingernails, these are definitely worth more than that. I knew that he was lying about his income because he was the owner of the salon, and I know what they charge there. And so I asked on the spot, the mother of his children, tax me, and she had it on her phone. Most people don't have this type of information at their fingertips, so it would be good to do this ahead of time. I didn't know to do that ahead of time because I'd never been in family court before. And long story short, after 4 hours of being in the family law courthouse, or family law area of the courthouse, we got her $782 a month in child support, and to this day he still pays it. So that is not really a consumer law case, but I talk about it because I am a consumer of my manicures and pedicures, and that is how I met this woman. And it is truly one of the most rewarding things I've ever been able to do. And I didn't know what I was doing, so you too can do it. So this is another case I had, a construction defect case, where essentially my client found a roofer on Craigslist. Another thing to think about when you take on these cases, sometimes people are finding people on the internet. They don't do a lot of investigation to see if the guy is reputable or has a good business history. So my client found this roofer. Long story short, he took a bunch of money from her. He never fixed her roof. He left the roof open and put tarps on it. This is not her actual roof. It's just an example of what one would look like. And there was water intrusion, property and contents inside the home were ruined. Her 3-year-old daughter stepped on a nail and punctured her foot because the contractor left debris out. And so eventually, she had to start all over from square one and go find a different roofer, and didn't have the money to do it. So we ended up suing this contractor who had gone out of business at the time. So he was very difficult to serve. Eventually I did serve him, and I got a default judgment against him because he didn't answer the lawsuit, to the tune of $250,000, which was great, except for the fact that, of course, we couldn't recover the $250,000. But what you can do in that situation, which is what I've done for multiple clients, is you get a judgment. I've learned this being a consumer law lawyer but you can record a judgment and do that every 10 years. And so the judgment will always be on defendant's credit history. So same thing with this case. So another very rewarding part of my career, my client, LaToya, had a case, LaToya Smith, where we handled her guardianship for her child. And then she came back and said, could you help me with my car deal that's gone bad? So essentially her sister co-signed, she co-signed a contract for her sister's car. So remember how I was telling you about family members being a potential conflict? Well, this is Exhibit A. Her sister defaulted on the loan. And so unfortunately, LaToya was in a situation where LaToya, because her sister had bad credit, was the one who became the sole signor to the contract. And the reason for that is because the shady car dealership manager LaToya into being the sole signor. And why do you think that is? Because she had better credit, and he could make the deal go through if LaToya signed off, but not if her sister signed off. So he essentially bullied her into being the sole, even though I don't want to do this, I cannot pay for this. He basically coerced her into doing it. And I had all the evidence to prove that. So essentially, her sister defaulted, and then LaToya became responsible for paying back the note. And she said, I can't do this. The note's become due and I can't afford to do it. And so I was able to bring a suit against the car dealership, alleging that the manager basically conned her into signing off on this note. And I got the mortgage company to release the note so that she wasn't owed any money, and we returned the vehicle, and LaToya came to my office and said hallelujah and started crying. So it was a very good result. But the fact of the matter is the contract was paramount in that case, and so were the actions of the manager. So because she had signed the contract, there was really no way of getting out of that contract. And I told her up front, I don't think I can contract, but a strong letter with a bunch of DTPA violations alleged in it, and commentary about what the manager did, which was very egregious. I don't have the time to tell you what he did. Provided an opportunity for a settlement and a good result for the client. So even though a contract legally may suggest you have, sometimes the actions of the personnel create a different story. So this is a sad case where my client, Mr. Leggins, was caring for his disabled grandson. So his grandson had mental disability as well as physical disability, and Mr. Leggins was caring for him. And during the holiday season, this tells you how long I've worked with DVAP. This was in 2015. Mr. Leggins' grandson's car was repossessed from Mr. Leggins' property in a very careless way, and I would even say reckless. So during the repossession of his grandson's vehicle, it caused severe damage to the gas pipes on Mr. Leggins' property. So the city of Dallas condemned Mr. Leggins' home, and this is in December. And I know right now we're all sweating and it's ridiculously hot outside, but in December, it's a different story some years. And this particular year was a cold December. And so Mr. Leggins and his disabled themselves, they both walk with a cane, had to heat the inside of their home with 2 propane tanks, which those of you who have used propane know that that's not a good idea. So Mr. Leggins himself represented himself pro se, filed a lawsuit in small claims court against the car dealership and the repossession company. Neither defendant answered. So Mr. Leggins obtained a default judgment, again by himself. I cannot take credit for this. And then the car dealership got a lawyer, appealed to the Dallas County Court at Law number 5, which used to be Judge Greenberg. And the car dealership failed to show up at trial. So the lawyer for the dealership files an appeal and then he fails to show up for the trial date. So appeal and a motion for new trial, which is when we got the case. And so we showed up at the hearing. Mr. Leggins came with me, grandson, and the dealership showed up also with their lawyer. And we actually won the motion for new trial. The court denied the dealership's motion for new trial. And after the hearing was over, the dealership actually came over and asked if I would represent them and proceeded to fire their lawyer. Now, this is not why we were doing pro bono work to get new work, but sometimes you do end up getting a referral. This is a case that I just finished handling, and unfortunately, this is a good example that not all cases result in a victory, and sometimes wish you. So in this situation, I was representing Mr. De Los Santos, and a good example of the attorney-client privilege being an issue is that he does not speak English, but his wife does. So his wife would always be the one to call me, but I would want to speak with him because I was representing him. I'm not representing her. But I mean, I can only speak to him because I speak fluent Spanish. So remember, when you're taking on cases, that sometimes DVAP will specify Spanish speaker needed or preferred. And sometimes it's not just because it's a communication issue, but it can become a privilege issue. So in this case, you know, the wife would call, and I would return the call of the husband, and we would speak in Spanish. And essentially, he took his car, and this is actually where he took it on the map, to Worldwide Transmission Repair. Now, if you go over there to that location, it has since shut its doors. So the general manager, total shady guy with a huge criminal history, basically told my client that he would repair his transmission. And when my client got the transmission or the car back, the repair shop said, I need more money. He gave him more, and then he didn't return the vehicle to our client. So my client showed up to get the vehicle back. Unfortunately, when they wanted to charge him even more money to fix the transmission. So my client takes his vehicle, goes to another body shop, at which point they said the repairs that he told you that he made were never made, and there's going to be a cost to fix the damage that he has done. So we filed a lawsuit. Of course, there was no recoverability against the manager or against the business because the business was manager. And so I did get a default judgment, and we did record the judgment, both in Dallas County and also in the county where the business was domiciled, which it has escaped me which county it was. Oh, I think it was Travis County. So we filed we recorded 2 judgments in 2 counties, and I've sent a letter to my client. And again, if you ever want a copy of any of this correspondence, I have it in English and Spanish, explaining to him that it's now his job to record the judgment in another 10 years for it to remain on the transmission repair company's credit, as well as the manager of the repair company. So those are things that people don't necessarily know that they have to do. So anytime you are closing a case and you are perhaps in a situation where you might want to have a payment plan continue, but you don't want to have your file open for 10 years, what I would do is I would make sure all of that is documented so that your client knows, okay, every month, you need to be making your payment, or you need to be receiving a payment, or every 10 years, you need to record your judgment. What I said to my nail technician is, because I don't go to that particular salon anymore, I actually go to her sister-in-law salon. By the way, you need to make sure that he's paying that. And when he's not paying it, you can call me, but we would probably have to reopen, pardon me, a new DVAP case. And I'll give you a real world example. I don't want to show you this on my phone, but I did just get a letter from the Attorney General from the state of Texas sent to my client, the nail technician, and then also sent to me because I've represented her once. So they always send everything to me. And this was, 2017, I probably represented her. So this is 6 years later, notifying her that she's no longer receiving public assistance, which tells me that she probably would not qualify for a pro bono representation, even though she did then. So again, another reason to remember that just because you represent someone one time doesn't mean they're always going to be a qualified pro bono client. Some people also change. My roof client, the one that had the bad contractor, I will tell you that several years after that, she called me and asked me to help her on something else. And I went to her home, and the vehicle that she was driving was nicer than my vehicle. The handbag she was carrying was nicer than my handbag. And while that does not necessarily mean that disqualifies her from being a pro bono client, something didn't sit right with me. And I asked DVAP to rerun the numbers, and sure enough, she did not qualify. So again, we want to help the people that really need help, and the people that maybe just don't know how to manage their money or looking for a free shake. That's not what we're here for. So with that, I will end my presentation. I see that somebody might have asked a question. I'm happy to answer or take any questions, or you're welcome to email me anytime, or my call, and ask us a question. If you have any pro bono consumer law questions that we can answer for you, we're more than happy to do it.